We are recording.
Good morning, everyone. Welcome to the Appellate Court. I'm Judge Bright. I'm sitting this morning with Judge Albert and Judge Pellegrino on the matter of Mcintyre versus Carbonaro, AC docket numbers 43751. This argument is being conducted over the Teams platform, so everyone is appearing by video conference. In addition, the argument is being streamed live over the branch's YouTube channel. I'm going to ask everyone to introduce themselves to make sure we can hear and see each other okay. I'll start with the judges, then counsel for the appellant, then counsel for the appellee. Again, I'm Judge Bright.
Good morning, Judge Albert.
Good morning, Judge Pellegrino.
Andrew Knott for the appellant, Your Honors.
Good morning, Attorney Vincent Amendola Jr. for the appellee, who is present here today with her spouse, Gerard Carbonaro.
Okay. I can see and hear everyone okay. I assume that's true for everyone else. If for whatever reason you are unable to hear anyone at any point, please let us know. If you're unable to see anyone at any point, please let us know. And if you get disconnected from the argument, please go back to click on the link and re-enter the argument. We will suspend the argument until we know that everybody is present. I'm going to ask everyone who is not speaking to mute their microphones to avoid any background noises and any feedback. The judges will do the same thing. If we have questions, we will raise our hands and ask counsel to recognize us. If you do not recognize us, then we'll jump in like we would in the courtroom. But again, we're trying to avoid feedback and unnecessary background noise. We are going to ask everyone to keep their cameras on at all times, though, so we can make sure everybody is present and fully engaged in the argument. Although we are all remote, this is a court proceeding, and we expect everybody to conduct themselves as if they were standing in the courtroom, 75 Elm Street here in Hartford. Each side will have 20 minutes to argue. The appellant can reserve some time for rebuttal. I will keep the time because we do not have our light system. I will hold up signs when you have 2 minutes left, when you have 1 minute left, and when your time is up. So with that, I think we're ready to proceed. Attorney Knott, are you ready to go?
I am, Your Honor. May I please reserve 5 minutes for rebuttal?
Absolutely. You may proceed.
Thank you, Your Honor. May it please the court that I start with just the undisputed arc of the story. We have a marriage that had 2 children, that then they started UTMA accounts. They had a 3rd child. On the advice of a bank representative, they took the 2 UTMA accounts, moved them to the TODs, and then later on they got a divorce. Then there were post-judgment proceedings. My client spent the money on legal fees on the advice of counsel, and then fast forward when it came to light.
Excuse me, Attorney Knott, you said that's an undisputed fact. Did counsel testify at any point in time during this dispute?
No, Your Honor, but the court found that fact in its decision.
What page is that?
Thank you, Your Honor. In the findings of fact,
well, it's okay. You can give it to me during, after the appellee.
Thank you, Your Honor.
And yeah.
And then, Your Honor, upon when everything came to light, he returned the money. And so this case, Your Honor, is ultimately what I think is the empty head, clean heart case. Everything he did was relying on someone who was telling him to do it, at least that it was okay.
Who other than counsel were the someones?
The bank representative, Your Honor.
Did that individual file an affidavit or testify?
No, Your Honor. But however, in that case, we know that's the situation because the defendant in this case actually brought brought a FINRA claim.
As part of the settlement of that suit, did the bank individual admit to providing that advice?
No, Your Honor.
Thank you.
secondly, Your Honor, referring to the issues now, the first issue where the court appointed 3 guardians, that's an issue. There's only one issued, and that was DM, Douglas Mcintyre, Your Honor. He's reached the age of majority now. And so the court had no authority to issue orders on any of the other kids. There was a custodianship of Rolt Mcintyre. There was never even one of the current minor SM. And so I think that's a pretty clear issue. I'd like to move on to the second one regarding nomination of the custodian, Your Honor. Regarding the nomination of the custodian, the question for the court is really, what effect does a stay have on the ability to nominate under 559? My client was removed. He was then, by the probate court. He then took an appeal to the Superior Court. He then filed a motion for stay, which was granted. Under 559, 45A 559, at any time may the custodian sign a nomination. 45A 186 says that we have a de novo appeal, and then we have our stay. So the big question for the court is a de novo appeal de novo, and what is the meaning of the stay with respect to the nomination? The court, I've already suggested.
So, yes, it's a de novo appeal, but it is still an appeal. So at the time that the probate court issued its decision, this alternate trustee had not been identified, correct?
That's correct, Your Honor.
So then how is this an appeal if the factual circumstances have changed since the probate court issued its order?
Well, it's a de novo appeal by 186, Your Honor. And so that means that my understanding is that we're starting over, as if nothing happened before, especially in light of the granting of the stay, Your Honor.
All right. Thank you.
The next issue, Your Honor, pertains to the burden of proof. And the burden of proof and the distinguishment of Cadle by the trial court are really wrapped up in one another. The court clearly stated in its decision that the plaintiff did not my client did not bear the burden of proof. And I think that's enough to make it clear that the court applied the wrong burden of proof, because we did not have it. It was even, the case law is clear. But when you combine with how he distinguished Cadle, how the trial judge distinguished Cadle, what seems to be happening here is that in Cadle, it was the losing party who thought that the burden of proof should be on the other side, should be on the fiduciary. So the court essentially adopted the losing party's position in Cadle. And so that is not the law of our land. And so we did not bear the burden of proof. And I think that alone is enough to kick this case back, Your Honor. The wrong law was applied. We did not bear a burden of proof. Brother counsel discusses the burden of production versus the burden of persuasion in his brief. I don't see that as, I see that as inapposite, Your Honor, because under any analysis, he still bears both. And so when the court said that it applied that we did not meet our burden, yes, Your Honor.
So what facts were in dispute that you believe the burden of proof matters on? Because you started this by saying that there are certain facts that are undisputed. Your client moved the money out, used it to pay legal expenses, and then when it was brought to his attention that that was improper, he put the money back. So what fact was in dispute as to which the burden of proof matters?
I think it's the application of really the law to the facts, Your Honor, here. I mean, there's a few facts that were in dispute with respect that we didn't really get into in our brief, Your Honor, and so I'm happy to go over them, but it's not really in the record. But our position is that it's the improper application of the law to the facts.
So explain that specifically to me, how that manifested itself in this case.
Thank you, Your Honor. In this case, what we ended up having is the gentleman, my client, he took the money. He had a second kid, or I'm sorry, he had a third kid. It's pretty clear why they moved it from custodian to TOD. You know, they divided it up there, and then on the advice of counsel, which Your Honor, I will get Judge Alvord on my break. At that point, he did it under the advice of counsel. He spent the money, and then here he paid it back. If you apply the law here, he fixed the problem. There was no ongoing duty whatsoever. The Superior Court seems to indicate that he had unfettered access as a result of this movement of money. That's not true. He had unfettered access to the money from the very beginning when these were custodial accounts. It seems.
Wait, hold on a second. When you say he had unfettered access, I mean, yes, as a practical matter, he could move the money. But do you agree that when they were in the UTMA account, he owed a fiduciary duty?
Yes. In fact, he not only owed a fiduciary duty there, he owed a fiduciary duty when they were in TODs, because in his mind, there was no difference.
Well, when you say he owed a fiduciary duty when they were in the TODs, because in his mind they were no different. As a legal matter, a TOD account is different than an UTMA account. If I put money in a TOD account and name my child as the beneficiary of death, I don't owe it a fiduciary duty not to spend that money, right?
That's correct, Your Honor.
Whereas with the UTMA account, I do owe a fiduciary duty not to spend the money, right?
Of course, Your Honor.
So there is a difference between the fiduciary duty for each of those two accounts.
From a legal perspective, yes. My client did not see the difference, and I think that's key here. Additionally, but the point that I was making pertains to access, and that is what the trial court was referring to. And there is no difference. That's the very point of a custodianship under UTMA. There isn't a probate court, generally speaking, overseeing this. The custodian has complete access, unfettered access to the accounts before and after.
So, but you did not object, or your client did not object to the jurisdiction of the probate court to hear this application, correct?
That's correct, Your Honor.
So let me go back to the burden of proof, because I still am trying to figure this out. Are you saying that the court imposed the burden of proof on your client to prove that the extraordinary remedy should not issue, as opposed to putting the burden of proof on the defendant to prove the extraordinary remedy should issue?
Yes, Your Honor.
Okay.
Additionally, Your Honor, the controlling case, Cadle, and then Ramsdell and Phillips, the court essentially distinguished away, and the real problem with it is the distinguishing factor for the trial court was that the beneficiary in our case did not choose the fiduciary. That was the reasoning to distinguish Cadle. And that same thing happened in Cadle. The beneficiary did not choose the fiduciary because it was a decedent's estate. And so that distinction doesn't have any bearing on our law, Your Honor. As a practical matter, the majority of these cases it doesn't bear because most of them pertain to decedent's estates. Only in some cases, maybe with conservatorships, are you going to be dealing with that in trustees. And so in all of those cases, the court went out of its way to distinguish both Cadle, Ramsdell, and then Phillips. And it seems to me that that was misplaced, Your Honor. And what it seems like the court was applying a lot of rules that pertain to guardianships of estates, not custodianships. That's in the methodology of its arguing. It seems underlying it is that this was already under the jurisdiction of the probate court before. And Your Honor, though, with respect to the clearly erroneous issue with this pulls right into, I'm very well aware of the standard of review. But the issue that we have here is that if you take a look at the court's decision, the court went and ordered that the new fiduciary can't spend any money except for certain limited circumstances. That's not in our law either. What the court could have done and should have done was appoint the fiduciary and bond them. That is what the law permits, Your Honor. And that statute is 45A 558. And so, thank you, Your Honor. And in 558, yes, Your Honor.
Was your client bonded?
No, my client was not bonded before. The court wasn't involved before, Your Honor.
But you're saying it would be appropriate under this situation for the new fiduciary to be bonded?
Yes, Your Honor, because 558 allows for that. What it says is that generally speaking...
How is that error if it only allows for it? Don't you have to provide facts?
Well, Your Honor, what I'm saying it's error because the statute doesn't allow for the restrictions that that were placed on the fiduciary. But the restrictions that it does allow are the requirement of a bond. And here's the point. If the court's going to bond anyone, the court could have ordered and should have ordered that the least my client, who there was no ongoing problem with, and would have been bonded because, yes, Your Honor.
What are you seeking here?
Well, I'm seeking a retrial, Your Honor.
A retrial?
Yes, Your Honor.
Okay.
And, Your Honor, I'll reserve everything else for rebuttal. Thank you.
Sorry, you'll have 5 minutes left for rebuttal. Attorney Amendola, ready to go?
Good morning. May it please the court. This case came to the court, the probate court initially, because there were numerous violations of the Uniform Trust to Minors Act account, which is under the exclusive jurisdiction of the probate court. And I've laid out all of the violations in my brief, which really equate to withdrawals of more than $5,000 and then expenditures of UTMA funds that were contained in TOD accounts.
Attorney Amendola, I have a question. Page 8 of the memorandum of decision, the court sets forth the defendant appellee's claims. There are 8 claims there. The first 6 claims reflect the withdrawing of UTMA funds and depositing them into TOD accounts, correct?
Yes.
Judge Grossman, the month before the probate complaint was filed, addressed those activities, correct?
Correct.
Did you bring Judge Grossman's decision to the attention of the probate court?
No, I did not.
Why not?
Because I understood them to be the probate court and the superior court to be courts of, jurisdiction where it could be concurrent. So in the case of Judge Grossman, she had made a conclusion that the UTMA account was in fact no different than a TOD account because they were both custodial. We brought that case to the appellate court, and then realizing that I could bring the case to the probate court, I did that and withdrew the appeal. And in fact—
So you sought another bite at the apple at the trial level with the probate court?
I wouldn't characterize it as a different bite at the apple. It was an alternative theory under the law, because when I brought the case in the family court, I initially brought the case as a non-disclosure on a financial affidavit case. As I mentioned in the brief, the TOD account was not listed on the financial affidavit at the time of the divorce trial.
None of the funds Judge Grossman found were listed on the financial affidavits of either parent, correct?
Yes, Justice.
And Judge Grossman also found both parents not credible as to their claim of no knowledge with respect to your client, not reliable or credible, correct?
Correct, Justice.
Yet you brought those same exact claims to a different adjudicatory body that would be seeking another credibility determination, correct?
No.
Oh,
because in the probate court, that was strictly a statutory remedy, as opposed to the family court, which is a court of equity. We did not argue the UTMA statute in the family court because I understood that to be in the exclusive jurisdiction of the probate court. So I did not see that I was precluded from making a statutory argument of multiple violations of the Uniform Trust of Minors Act account in the probate court. So they were two different issues, Judge. In fact, the issue is whether or not Judge Grossman found one or both clients credible or not credible. The simple fact was we had withdrawals from the Uniform Trust of Minors Act account in excess of $5,000, and then that money was spent beyond the statutory threshold of $5,000. That's the part of the unfettered discretion or the unfettered access, excuse me, that I think is part of the gravamen of this case.
And when were those withdrawals?
Those withdrawals, the first withdrawal was in 2010, March 23rd of 2010, when the funds went into the TOD account. And then it wasn't really until sometime in late 2014, early 2015, that the TOD monies were being expended by the appellant to fund post-judgment divorce litigation. So the money belonging to the children that was originally in the UTMA account was used to fund post-judgment divorce litigation.
I have a quick question, one last question, then I won't take up all the airtime here. The settlement of $15,000 on the FINRA issue?
Yes.
Those funds went back into the children's accounts?
No, they did not.
Where did they go?
I believe that they were retained by my client. My client expended well beyond that for this litigation. And I do think that that would probably be part and parcel of a continuing accounting with the probate court, because the probate court still retains the accounting aspect of this case. I'm
confused. What is part and parcel of the continued accounting? Those funds were received when?
I want to say, Justice, somewhere around the spring of 2019.
Okay,
I could find
so
that.
we're talking 2 years ago. Years ago?
Yes, Judge.
And the disposition of those funds have been submitted to the probate court?
No, they have not yet.
Well, how would that be continuing?
Well, because depending on what the court, well, let me back up. No matter what the court does with this case, we still have a motion for accounting of funds that go beyond just the funds of DM in the probate court. So regardless of what happens with the case at this level, the probate court, which has exclusive jurisdiction over this accounting, has not completed its work.
So if I could follow up on that, am I correct that you were in the probate court on this case in 2017?
Yes, sir.
And in 2019, your client received $14,999 on behalf of the children, did not at any time put that money into the children's account, and did not inform the probate court of that. Do I have those facts correct?
Yes, you do.
Okay, thank you.
Justice Alvord, did I finish answering your question? I wasn't sure if I did.
Yes, and I'm only a judge.
Judge, thank you. So where I had left off was that so the case went to the probate court seeking removal of the appellant as the custodian, and so we conducted we had a trial de novo at the Superior Court, which brought us to this appeal, and there are particularly 6 issues that the appellant raised in his appeal. The most pressing of which that I would really like to talk about this morning would be the burden of proof issue, and the issue concerning whether or not the court followed the Supreme Court's precedent in Cato and its progeny. I will say that when you look at the memorandum of decision, without question, the court accepts the case precedent of Cato, Phillips, and Ramsdell. I think where the court made the comments about the case not being controlling is that they were distinguished on the facts, but not on the particular case precedent. And I would like to point out one important thing. In the transcript, on the bottom of the first page at lines 21 through 27, and at the top of the second page on line 1, we brought to the court's attention that it was the appellee's burden of proof in this case, and the court acknowledged that. So I think that when the court, well, not I think, when the court stated that the appellant failed to meet his burden of proof, the court was relating to the fact that there was no evidence produced to rebut the presumptions raised in the case in chief of the appellee. And as a matter of fact, the evidence in this case was overwhelming, because the evidence you could see in the appendix consisted of bank records that are uncontroverted, without question, confirm that money was in fact withdrawn, money was in fact expended, all of which was in violation of the Uniform Trust to Minors Act. What I did do in my brief. Yes.
Attorney Amendola, do you agree that it was the appellee's burden of proof to prove that this was an extraordinary situation that warranted the removal of the appellant as the fiduciary?
Yes, that's absolute.
So the underlying facts may not have been in dispute, but that conclusion as to whether it was the situation was so extraordinary as to require the removal was the appellee's burden. And what do we then make of the trial court's statement regarding that issue, that the appellant failed to meet his burden of proof?
Well, I can say, if you were to examine the record is explicitly clear that we were the proponent of the evidence initially because it was our burden. We went forward with the evidence. The evidence that we presented overwhelmingly established multiple violations of the Uniform Trust to Minors Act account. And in fact, the court points out in its memorandum of decision that had it not been for the court's intervention, the access to the funds would have continued beyond that. So the point that the court was making, that when this matter came to the probate court, without question, there was unfettered access, and the estate had in fact been wasted. Wasted in the sense that about $22,000 of UTMA monies arguably were expended for post-judgment litigation. Yes, Judge.
But Attorney Amendola, you answered Judge Bright's question with respect to the $15,000, which is close to $22,000, in such a way that I wonder that both the trial court, or particularly the trial judge, wouldn't have been better served by knowing about that $15,000 settlement and where it went, because that also was utilized in the same sort of manner that the plaintiff appellant utilized the $22,000. I'm just completely perplexed about that $15,000 settlement. And why the probate court that information was not shared with the adjudicatory body.
When you say the adjudicatory body, I believe you're talking about the trial court. Are you not?
Yeah, the trial court, okay. For sure.
Well,
obviously, the probate court, that decision was final prior to the filing of the FINRA complaint. Is that correct? I'm sorry, Judge. Was the probate court decision released prior to the filing of the FINRA complaint?
No. The probate court decision?
Yeah, the probate court.
Yes.
Okay.
Yes.
So let's talk about the trial court with respect to this de novo review. The $15,000. You mentioned the $22,000 unfettered access used for things other than the kids. Ditto for the $15,000. And it seems to me this trial judge would have been well served to know about that money.
Well, Judge, just a couple of points I want to make. This trial de novo takes into account everything that happened up until October 17th. Everything that happened after October 17th, I think, is a question that is to be raised, certainly at the probate court, and I do respect what you have just said, Your Honor. But for purposes of this appeal, we are concerned with what happened at the probate hearing and what the result of that was. Not something that happened about 18 months, give or take, post the decision that we're arguing about here. And I'm not sweeping this under the rug. I'm saying it. You raise a valid point, but I don't think that issue has any impact on what happened in this particular case for purposes of the issues on appeal. I say that very respectfully, Judge, because I do take your comment to heart. So just to continue on, I do think that without question, we proved our burden in this case. We had the burden of proof. I do think that the facts submitted into the record clearly establish that we proved that this was a case of an extraordinary remedy because the assets had been wasted. The assets continued to remain in a TOD account, and in fact, if you look at the record, the funds were not really put back until like April of 19, if my memory serves me correctly, March or April of 2019. So here we are with an October 2017 judgment. We're at the appeal on the eve of trial, and all of a sudden the funds show up in the UTMA account. I think that is just another example of defiance of what was right under the law. So I do think that the court, when it said the burden of proof, that he didn't meet his burden, and I expressed the cases in my brief. I talked about Baxter and Sortito and Potter, where they talk about the burden of proof having two meanings. i.e. the burden of persuasion, which certainly was on the defendant appellee, the burden of producing evidence, which goes back and forth on both parties. It's very fluid. As evidence develops into a case, I think that burden shifts back and forth. One of the reasons why I gave such an array of cases in my brief is because I wanted to, thank you, Justice, I wanted to impress upon the court that in a variety of circumstances throughout the land, throughout our country, our system of jurisprudence has really interpreted the burden of proof in a variety of different ways. So I don't want to be so cavalier as to say it's semantics. It's beyond that, but it's very clear to me that when you look at the record in this case, the court's statement that the plaintiff appellant did not meet his burden of proof, not the burden of proof, his burden of proof. His burden of proof was to produce evidence sufficient to rebut the evidence that we put up in this case, which really did prove this case.
Okay, I just want to be, I know the time may be up, Attorney Amendola, but I just want to be sure because I started out a certain way and I just want to finish that way. So page 8, the defendant appellee's position, the 8 enumerated issues, you're focusing on issue 7 and 8, correct? And you're not seeking a second bite of the apple with respect to issues 1 through 6, because Judge Grossman found with respect to issues 1 through 6 that the evidence supported the husband's claims that the wife knew the funds were in a combination of 529 and custodial accounts. So you're not seeking a second bite at the apple, a do-over with a different trial judge on issues 1 through 6. Is that correct?
No, I think what we're saying, Judge, is that there were 529 accounts and there were other accounts that were not disclosed.
I'm referring to the second to last and third to last sentences in Judge Grossman's May 1st, 2017 opinion. And she is a colleague of Judge DeAndrea. And she found precisely as stated. And so that takes care of issues 1 through 6. As far as your client alleging that that's an issue because she found your client knew about this. So I'm having trouble balancing that, but I think your time's up and I apologize for taking more time.
Okay. That's fine. Attorney Knott, you'll have 5 minutes for your rebuttal.
Thank you, Your Honor. First, Judge Albert, I'd like to direct the court to A23. The 5th line down indicates that the trial court found, and I quote, plaintiff appellant upon the advice of divorce counsel withdrew money from the TOD for fees and costs associated with post-judgment divorce proceedings.
I'm sorry, where are you?
A23, 5th line down.
A23 of your appendix is a motion for stay.
Is this your appendix, Attorney Knott?
Yes,
yeah, right. Judge Bright's right. What are you talking?
A23 of your appendix.
I'm sorry.
A123.
Thank you, Judge Pellegrino.
A123.
I'm just a judge too.
A123. I'm sorry.
5th line down, Your Honor.
5th line, 1, 2, 3, 4, 5. After litigation, they have upon the advice of counsel. So you're saying that this judge made that finding with absolutely no evidence other than the testimony of your client? That's it, right?
Yes, Your Honor. He made it based on the testimony of my client. I would like to point out one thing where a point that I disagree with Brother Counsel on, Your Honor, where it was indicated that we're limited to the facts as of October of 2017 at the probate court. I don't think that's what 445A 186 says. We get a de novo appeal and we get to start all over again. That doesn't mean we start all over again with the facts there. I think we could bring in whatever we need to, even new information. Basically, in sum, Your Honor, my client made mistakes on the advice of others. We admit that he clearly violated the law, and he fixed it. He paid it back. And then in the court, though, without really any showing of continuing harm, this and no really danger of anything going on in the future, appointed the mother who, as the court already pointed out, did the very same thing with the $15,000. Our position is that
just to let the record reflect, I did not say the very same thing. I just questioned the tracking of the $15,000.
Thank you, Your Honor.
Thank you.
The court really had a duty to engage in the least restrictive means of intervention, try to fix this problem short of removing. And the court, as I indicated previously, could have just ordered a bond and called it a day, and stayed in line with Cadle, stayed in line with all of its ancestry. But the court instead distinguished Cadle, held that we did not meet our burden of proof, which we didn't have, and then appointed the mother when there was a nomination involved.
Attorney Knott, did you request a bond to be ordered? I haven't read the transcript.
I have not.
You did not request a bond?
I did not request a bond to my knowledge, Your Honor. I don't recall specifically.
You don't know what you requested of the court?
I requested that we win the case, that my client not be removed.
Did you offer that your client would post a bond when you said that your client not be removed?
I do not recall, Your Honor.
Okay.
I have nothing further unless the court has questions.
See no further questions from the panel, so we will take the matter under advisement. Thank you both for participating in the virtual courtroom today. We will stand in recess until 2 o'clock this afternoon. Have a good day.
Thank you.
Thank you.